You ready?
Judge, yes, we have
What's
two
wrong with
other
this?
arraignments, but I don't know that council's here. Counsel for Leon or counsel for Navarro?
Guys, you don't have an arraignment, do you? Over? Okay.
It was, well,
Well, okay, so who's the first one?
page 20, top of page 20.
Okay, who's the next one?
The other one is top of page 22.
Okay, I don't have either of the phone numbers, so I guess we'll just wait.
Okay. Counsel for reset? Yes. Are you all together?
Okay.
Oh, one at a time.
Still call one out. Yeah, see you guys.
Come on up. Yeah.
You did?
We're waiting on lawyers, so come up, talk to me.
Oh, okay.
Yeah.
I didn't know if I could approach or not.
Yeah, of course.
Approaching on a case from yesterday, Helen de Alvarado Mejia.
Okay.
I was here yesterday. I talked to Blaze, got everything settled. We had a offer of PTI. Made a big blunder though, Judge. I forgot to reset the case. I took off without resetting the case.
Yeah, so
And so, well, it was moved to today and she's set for bond forfeiture today. Can we
she
reset
here
it?
yesterday?
No, her appearance was waived yesterday.
Okay, so, you're accepting the PTI?
I'm sorry?
Accepting the PTI?
Yes, I talked to her yesterday. She wants to do the PTI. She's registered for it, so we're on track for the PTI.
All right.
Can we reset it?
Yeah.
Okay. Do you care about how long?
So, I mean, it's kind of old, right? It's from November.
Well, we got offered the PTI yesterday. I'm hoping for at least 2 weeks.
Of course.
Is that fine? Okay, thank you, Judge. I'll reset that. Appreciate it.
Counsel for reset?
She is set for bond forfeiture and she's not here. Are we okay with that?
Don't worry about it.
Okay, sounds good. Thank you, Judge.
Yeah, hi, Josh.
Yes, Josh. I have a quick question for you on this Halbert Jones. It's Halbert.
Is Jones the last? All right, I see it. Okay.
A few last names, yeah, Halbert.
Yeah. Oof, that's an old case.
Right, so it's old. So we've got a PTI offer. She's made her donation and she's halfway through the 2-hour class. And we're just asking for one more day to finish the class. She's
Halfway through the 2 hours.
started on it last night and then is still trying to finish it up
All
today.
right, what's it tomorrow? I'm gonna roll it day for day until she gets to.
So, thank you.
Good job.
Did you get your videos?
We had an offer PTI yesterday, we did a short set.
What was the PCI? Okay. Is 8
Excuse me, Your Honor. I sense a lull in activity. I just wanted to see if I could approach quickly.
Okay.
Judge, I forgot when Your Honor asked me. My client is in ICE detention, so she's not going to.
Do you have proof? If you can give me proof that she's actually in detention, then we'll just reset the case and we won't, revoke or forfeit.
Yes, Your Honor. If I could have a few minutes, I'll see what I
Take your
can.
time, no rush.
Thank you.
There's a way, Mr. Moody, there's a way to look on their webpage, the ICE webpage. If you have like the A number, you can see and you can pull up when they're set for some kind of master hearing or whatnot. So, for what it's
Yes,
worth.
sir.
I don't know.
Yes, Judge, we're gonna go in there and see what we can find for you. Thank you. Appreciate it.
Hey. So I was thinking we would just do the time served on the one here. We'll just give you credit for whatever you have.
Okay.
And then, the other one gets dismissed and then we will move. Yeah, then done. So, all we would need is just, do you file the stipulations, right?
Yes.
You guys, yeah, so, and then, how much credit does, page, let me see which one this is. No, he's on bond. It's page 7, but I don't know which one it is.
Miles Craig.
The MHA or the?
The MHA, we're going, it's the MHA. The other one's getting this, so it's
How is?
the 249.
We got 230.
What is it?
232.
It has 232 days credit, so you guys write it whatever, however you want, you know? I guess maybe 180 for 180 or 2, whatever you guys want.
Okay, that's the sheet.
Yeah.
Is it Easter hair, bro?
Uh-huh, yeah, laziness. Thank you for coming back, Ms. Stewart. Iwoma, come on up. Allison Iwoma, come up, ma'am. Good morning, Mr. Osborne.
How you doing?
What's new?
Sorry?
What's new?
Oh,
Here we go.
just, the same old is new.
I feel you. I feel your pain. You are Miss Owuma.
Sir.
Ma'am, you are charged with driving while intoxicated, second offense. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge.
Okay.
On February 25th, officer dispatched to a minor crash with a disturbance at the 1000 block Upland Drive in Harris County, Texas. The officers made contact with two witnesses. The second witness stated she was driving her Lexus north on Upland Drive when the defendant, the sole occupant of the vehicle, was driving her black Camry south in the northbound lane. The witness stated she slowed down, honked to alert the defendant, and crashed into her car in front of him while going north. The first witness stated he was in the southbound lane and was stopped waiting to enter the service road, and the defendant driving her Camry struck the Lexus, and after the two motor vehicles crashed, the defendant swerved right and then ran into the back of the Chevy Blazer the first witness was driving. The first witness stated the defendant appeared to be looking down like she was slumped over, and the first witness approached the motor vehicle and the defendant appeared drunk. The defendant tried to drive off and the first witness was telling her to stop and wait. The second witness corroborated the first witness' statement and stated she could smell a strong odor of an alcoholic beverage and that the defendant was drunk. The officer made contact with the defendant and the defendant stated she was driving her car, had left home, and was on the way to the hospital for her ulcers. The defendant stated she was on the right lane going south and a lady in an SUV was going north in her lane. The defendant stated she swerved over and hit another car. She tried to exchange information and get off the roadway, but was not trying to leave the scene and only wanted to move the cars into the parking lot on the west side of the road. The officer observed a moderate odor of an alcoholic beverage, glossy eyes, slurred speech, and swaying. The defendant was within normal parameters regarding her vital signs per Houston Fire Department, and standard field sobriety tests were then conducted. HGN 6 out of 6, walk and turn 5 out of 8, one leg stand 3 out of 4. The defendant was read the DIC and consented to blood.
All right. So we have a DWI here. Any more DWIs anywhere else? If you run her NCIC, please.
She only had a previous out of 2022 here in Court 5, but that's the only one, Your Honor.
Does she have a valid Texas driver license?
It's not eligible, Your Honor.
It's not eligible. I want to make something perfectly clear to you, Ms. Sawuma. I'm ordering you as a condition of your bond not to drive any vehicle whatsoever for any reason unless you have a valid Texas driver license and liability insurance. I'm also placing a restriction on your license that you're not to drive any vehicle that's not equipped with an ignition interlock. I'm sending notice to DPS in Austin so that every single police officer knows if you're caught driving a vehicle and it doesn't have an interlock in it, they will arrest you and put you in jail. Do you understand? And then I'm going to revoke this bond here as well. You will be signing an affidavit with me today. Counselor, did you want to add something?
Manage the law is, that's incorrect. The cop did not say moderate, he said mild.
All right.
Sure.
Yeah, Judge, a minor automobile accident and a mild odor of alcohol is not any kind of probable cause for intoxication. I believe what happened was the police officer noted she had a prior conviction and then jumped to conclusions and ran everything backward from there.
Well, we have witnesses who say that she's possibly intoxicated. They do field sobriety tests. The field sobriety tests indicate that she's intoxicated or potentially intoxicated. So that's when they do the blood test. This is just a mere probable cause hearing. We have someone who's got indicia of intoxication, slurred speech, odor of alcohol, crashes into 2 different cars, fails 3 different field sobriety tests. You've got 2 other witnesses that say that she's possibly intoxicated, who they're on the scene and see it. There's more than enough to go forward for probable cause purposes. Beyond a reasonable doubt, I don't know. That's why we wait for the evidence to come in. But I think that there's certainly sufficient probable cause to go forward. They say you don't have a license, so you may not drive at all for any reason. I don't care what your justification is. I don't care if Bambi has to go to the hospital. You need to save 30 kittens. A kid needs to go to you cannot justify getting into a car for any reason. Do you understand? This is an affidavit that you're going to be signing today, promising me you're not going to drive. And if I find that you do, I can have a contempt hearing. You can be facing an additional 6 months of jail and a $500 fine every time you drive because it's an offense in and of itself. Do you understand? Because you don't have a license, because we're ordering you not to drive, I am now ordering you to obtain a portable breath test device that you're going to take with you everywhere you go to prove to us that you're not consuming alcohol. You're not to consume alcohol, illegal drugs, unprescribed controlled medication, and we will randomly test you as well. Now, good job on having a lawyer because you have one. I will waive your appearance, but it is your responsibility to stay in touch with them. If they tell me they can't get a hold of you because you're playing games and you're dodging phone calls, whatnot, I will issue a warrant for your arrest. All I'm trying to do is protect my city at all costs, and I will do it however I can. Do you understand? If that means putting you in jail because you become a public danger, I'm going to do it in a heartbeat. So for now, what I'm going to have you do is I will have you come up here, swear to us that you're not going to drive. Then I will get you to Victoria, where we'll have you sign a reset. You will get with Felicia for your bond conditions, and after that, you guys are free to go. All right?
Thank you, Judge.
Okay, guys. Thank you, sir.
Here's the PSR for Salgado.
Driver's license. And then you have
What's
a
that?
motor vehicle that approved ignition and a lock device properly installed in the vehicle. I need you to sign for this.
Roger.
Judge, may I approach?
Ready?
Yeah. Jury boss, it's a walkthrough request.
Do you need an interpreter?
No, you're on.
You can have this for you guys. You can actually see it.
So no priors? Roger?
Not to my knowledge, Your Honor.
Okay.
And who is this, Your Honor?
Let me give you cause number. You ready?
I got type 2.
53302.
Yes, Judge.
And then I guess before we leave, if you can run an NCIC to see if there's any other priors.
I typed the app again. I'm sorry.
No problem.
Salgado,
Yes, sir.
ma'am, you are charged with assault of a family member. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am. Okay.
Yes, Judge. The complainant and the defendant are mother and daughter, and the officers were dispatched to a residence in Harris County, Texas, in response to a family disturbance. The complainant told the officers that she arrived home to find the defendant packing her things. The complainant began discussing the defendant's life choices, which led to an argument. The complainant tried to get the defendant to stay at the home, but the defendant grabbed the complainant by the shoulder and shoved her against the wall, causing pain.
Ma'am, I'm going to find that there's enough probable cause to go forward with your case. Do you guys have the RIP done?
There is a rip on Your Honor.
What
Yes,
does
Judge.
does mom want contact with her?
It's my understanding she's okay with contact.
She wants contact, Your Honor.
Is she here now?
No, she lives in a separate home. Since that incident, she's moved.
So I want you to understand something, Ms. Salgado. I'm now entering what's called a magistrate's order for emergency protection. This is a court order that identifies Ms. Gonzalez as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon. Do you understand? If you violate this court order, the state can and probably will file a violation of protective order, and that is one of the worst misdemeanor cases that you can pick up. So just be nice. If you butt heads constantly, find another way. Go outside, do something else. But if you guys get into it again and there are threats made, you might end up back in jail. You understand? So this usually comes with a residential restriction that you cannot go back to the house. I will take this off. I am ordering you not to have any threatening or harassing contact with her. What is threatening or harassing doesn't matter what you think, it's what she perceives. So conduct in and of itself can violate this. You understand? Do you mind filing another threatening or harassing?
Yes, Judge.
Please. So bond,
Judge, we are asking for $100 pretrial bond. She has no history. Once she found out about the case, she hired us, and we're here presenting ourselves and availing ourselves to the court's jurisdiction. I don't think she's a flight risk or a threat to the community.
response?
And just, there is no criminal history, and
Okay.
given the complainant's statement to us, we wouldn't be opposed.
Okay, so I'm with you. I'll set bond at $100.
Thank you, Your Honor.
And then I'm going to grant you a PR bond. That means that I'm giving you a free bond today. But understand that I'm going to protect my community at all costs. If I find that you become a danger to my community, I will revoke that PR bond, issue a warrant, and put you in jail. No more. You will not get any more. Do you understand? Now, because you have a lawyer, I will waive your appearance. It is your responsibility to stay in touch with them, and they will tell you if and when you have to come back to court. Okay? All right, so I'll have you sign a reset with Victoria. We'll have you get with Fleischer for your conditions, and then you're free to go. Okay?
Judge, may we be excused briefly?
So, PR bond and $100.
All right, Judge, we have no arraignments. Page 12. Garrett, come on up. 13.
Good morning, Mr. Garrett. Sir, you're charged with terroristic threat of a family or a household member. That allegation kicks it up to a Class A misdemeanor, so you are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On February 25th, 2025, the officers were dispatched to a residence in Harris County, Texas for a disturbance with an unknown weapon at approximately 5:49 p.m. And upon arrival, the officers met with the complainant, who stated she is the mother of the defendant and they live together. The complainant stated that day her healthcare provider came to her residence to help her as she is disabled. And the complainant stated the defendant was in his room playing loud music, and the complainant asked the defendant to turn it down while her provider was there. The defendant did turn it down, and as soon as her provider left, he turned the music back up. The complainant requested the defendant turn the music down again, and a verbal altercation ensued over the music and money, and the defendant started to rip up family photos. The complainant tried to stop the defendant, but the defendant grabbed the complainant by her arms and pinned her against the wall. The complainant stated she did not feel pain, but that the defendant said to the complainant that if she continued to touch him, that the defendant would break the complainant's jaw. The defendant was on the scene and refused to speak to officers.
Okay. Mr. Garrett, I'm going to find that there's sufficient probable cause to go forward with your case. Do we know what mom wants?
See if a rip was attempted, Your Honor, and unsuccessful.
We have a call scheduled later this afternoon. She won't be available until afternoon.
This is a problem. I normally order in these types of cases that you're not to go back to this place. So if you don't have anywhere else to go to, what happens? You have to be careful in these situations, Mr. Garrett. So let's do this. How old are you, sir? I'm going to give you a lawyer today. I want you to talk to the lawyer so we can figure something out. I don't want to put you out on the street, but I got to protect every person here. You understand? So I'm ordering you as a condition of your bond not to consume alcohol or illegal drugs. I'm going to randomly test you. If I find that you're using anything, I will revoke your bond, put you in jail. You understand? You're not to be in possession of weapons as well. And you're not to have any threatening or harassing contact with mom. If I find that you do, likewise. You got out of jail because we gave you a free bond. What happens if we put it at 5 to 10,000? If you don't have anyone to bond you out, you'll be stuck like Chuck in there until this thing's over with. And it takes a long time just to get a 911 tape. You understand? So I'm gonna have you sign a reset. Let me have you take a seat in the jury box. I'm gonna find your lawyer and then we'll go to it. Come on.
You don't want to bring up that statement?
I got one.
All right, go ahead and sign for your reset. Judge, are we just appointing?
Please, I have an affidavit already. Hey, Doug,
Good morning,
what's up, man?
Mr. He on the docket this morning. I came by last week. He was out of town. He had gotten called for testing. You allowed him to test on Monday. As long as he tested negative, you were removing his requirement to do random testing to his travel schedule. He's negative. And so he spoke with his officer. Officer said he would need to come to court and sign.
Yeah, just get with Fleischer and then she can modify the conditions.
Perfect. He's here, ready to do that.
Didn't need to happen. We signature for future action. So that way they don't have to.
I just want to make sure that the officer wanted us to do it. So
Next time, come talk to me.
you got it.
And then, because we can always waive it so that they don't have to waste their time coming, you know?
Yeah, appreciate it very much.
And Judge, if this alone, whenever you get a chance, the law is right here. Yeah, the strawberries good.
Did you want to ready?
You want one?
That's it.
If I can put them on.
Mr. Moody, you ready?
Yes, Your Honor. I have
Do you want to
the,
send, if you can send it to Victoria, her email,
okay.
I'll take a look at it.
Yes, Your Honor, we'll do that. Thank
And
you.
then, we'll get you a date.
Okay, Judge, I will send it to
Please.
Victoria. Thank you.
Hey, Vic,
Yes.
on Mr. Moody's case, he's sending you an email with the ICE stuff.
Okay, I'll forward it to you.
No, just open it and you need to do it.
There's something attached. It's like an email that we typed. That's why it's legal.
No, Mr. Moody, there's a certain, like, I don't need you to type what happened. There's a printout from ICE, like an actual web page that says on theirs, yeah, hold on, let me see that. Hold on. That's it.
Yes, Judge. This is what I was going to send to Miss
Okay,
Victoria.
I got it. All right, that's good enough for me.
Okay, thank you, Judge.
Yeah. So what day do you want? I don't care. You, whatever you want.
Whatever would please the court, Judge, sometime in late April.
Hey, Vic, what are we looking at? I saw what he showed me. That's good. It's all good.
Judge, how is April 29 or 30?
April 29th to 30th.
Yes, Judge, I'll take the 30th. Thank you.
Okay.
So if she does get out, if you guys are able to secure her bond and she's able to get out, we need her here to sign conditions.
Yes, Your Honor.
I just need her here for the initial arraignment, and after that, we'll waive it. Okay?
Yes, Judge.
Okay, thanks.
Thank you, Your Honor. Have a good day.
Take care.
Thank you, Judge.
Hi, Brandon. You ready?
Judge, how you doing?
What's going on?
Judge, I have a plea.
Can you step up that on the words as well?
Brandon, what you got, man?
Your Honor, it's a plea on Mr. Wiley.
Okay.
There you go.
You wanna bring them up?
Yes, sir.
Yeah.
Thank you.
Absolutely.
Yes, sir.
Good morning, Mr. Wally. So you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. You guys have worked out an agreement. They're offering you 6 days in jail with credit for the 2 days that you've done. Are you sure you want to do this?
Yes, sir.
I guess the prior evading is what,
Sir, we talked about everything, wanted to
just,
do this, Sean.
you need to understand that this has lifelong consequences. You know, you're entering into this agreement where this DWI will go on your record. It's going to be there for the rest of your life. It's even there after you die. The reason this is important is because if you get pulled over in the future, an officer will look at your record. They're going to see that you have a prior DWI. If they roll up to your window and they smell alcohol, they smell dope, it's probably not going to go well for you. Do you understand?
Yes, sir.
And from now on, what we're doing today, the proverbial slap on the wrist, from now on, it's a minimum of 30 days in jail. Do you understand?
Yes, sir.
So what I'm trying to tell you is that if you want to get lit, just don't get into a car because it's a huge risk you're taking. You're giving up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. So once you accept this, it's done forever. This is what you want to do. How do you plead to the offense, sir? Guilty or not guilty?
Guilty.
I'm going to find you guilty. I will sentence you to the agreement. I'm going to suspend your license for 90 days. Do not drive until you get a license. The other thing is this, Mr. Wally, is that DWI is big business. There's a $3,000 surcharge that tacks onto this because you pled guilty to this. I'm going to waive it for you today. But the DWI second is a $6,000 surcharge. So if you're not smart enough to consider how to get home on a night of drinking, get ready. It's minimum 30 days and a huge surcharge. Do you understand?
Yes, sir.
All right, good luck.
Your Honor, could you run the LR suspension, or the suspension concurrent with the LR suspension he already has? He had a suspension from October to April. We have the dates. 6 months, Your Honor.
I don't know, man. He has a prior evading that
No,
just,
that was the same transaction. They dismissed it, I believe, like the day after. It was.
it's out of the same, okay, all right. I will. Okay, all right, you got to get them the dates.
Yes, sir.
All right,
Thank you.
good luck, sir.
Thank you, Your Honor.
You got it, man. Hi, guys, come on up. Yes, of course.
I'm here for Mr. Thering on Jesus Lopez.
Okay. In jail or on
He's in
bond?
custody, Judge, and he has felonies pending. Fairly serious felonies pending. In this court, apparently they had offered a PTI for this particular case, but the prosecutors just advised me that that's been withdrawn. So I'm.
Not a big thing.
So Judge, Mark's got medical issues going on this morning. That's why he's not here. We just wanted
Yeah,
to
tell
see
him we're
if we
sorry
could.
that he didn't come by, you know?
Yeah, I'll see him probably later this afternoon, but just wanted to see if we could reset this case.
You want,
Go ahead and set it for the same date as the felonies.
we cannot do that because he's
Yeah.
in custody, but the day after.
Because I don't know a lot about felony cases, but Mark did imply that there was a good potential if those will resolve, which I think will take care of this case as well.
Alex, any offers in the felony cases or
Let's see. No, Your Honor.
there's still no offers?
No offers.
Okay, all right. So we'll set you for the day after then.
Thank you, Judge.
Assuming it's on Saturday. Let me see. Sure.
Have a good day, man. Be excused.
Give me a second. Let me make sure. Okay, yeah, it's a Friday. That's
Thank you,
cool.
Judge.
Okay, for sure. Ms. Strong. Hi,
How are you doing?
what's going on?
So I have Kimberly Hillshine on docket today for Kimberly Hillshine.
Okay.
She's here for an arraignment. She's on bond. She's not here. I will be in the building until noon if she shows up.
So she picked up 2 trespasses?
No, they refiled. So they dismissed the misdemeanor B, the regular criminal trespass, and then they kept the
It's
criminal
not
trespass.
dismissed yet.
Mhm.
It's not dismissed yet. Hey, Blaze, do you mind taking a look at this? Blaze, on Hillshine,
So yesterday, or sometime, the criminal trespass would be the.
Yes.
I got the dismissal email, but it's still looking like it's not dismissed.
yeah, yeah. No, it's already been refiled as an A, so we need the B dismissed.
Yeah, I'll refile the dismissal, Your Honor.
Okay, yeah.
Okay,
The thing is, she's not here.
she's not here. I will be in the building.
Say it again?
I'll be here until like 12 if she shows up, but she's not here, so, I mean, you have to.
Do you have contact with her or no?
I've never met her. I did a deep dive search to try to get a cell phone number.
How'd you get appointed then?
She showed up on the mental health docket list, and then I filed the appointment form for her.
Okay, I guess if she's not here, I'll set it at 2501. And then, if you ever get a hold of her, or when we get a hold of her, you want to stay on it or do you want to? What do you want to do? It's up to you. If you want to stay on, happy to have you. If not, then,
I'll stay on. I'll see if my investigations department can try to find her. If by,
okay. Yep. Oh, you want it signed?
Yeah.
Okay, don't file it. Don't file
Oh, I just did it. I guess
it. Okay, so just delete the new one.
I guess I'll recess in like 30 days, see if I can get a hold of her or not, and then.
Oh, no. She's not even, wait a minute, I'm just gonna revoke it.
Exactly, yeah.
If you get a hold of her, bring her in and then we can address everything.
All right.
But I don't want to just leave it,
Yeah, I'll stay on it until, I'll try to find her.
got it.
Thank you, Judge.
If she shows up, I'll call you.
Okay, sounds good. Thank you.
Thanks.
Since we processed the warrant today, it was clean up one thing.
Your Honor,
So.
Judge, I have Moses Garza on today's docket. We've been going back and forth about PTI program. He just doesn't think he can afford it.
For the DWI?
For the DWI PTI judge. We've been talking, I've been talking to him about all the fees that would be involved, and he does not think he can afford the program. Would you be willing to waive, if you want to do time served, would you be willing to waive the DPS fine and court
Is it a
costs?
second?
It's a first judge.
Yeah, of course.
You would, and the
I nearly
DPS
always do.
I'm s-
I nearly always do.
Okay, just wanted to make sure,
Yeah,
Judge.
of course.
And the DPS fine as well? Okay, thank you, Judge.
I've got a plea for you, Judge.
Morning, Judge.
Yeah, I'm Jonathan Lopez.
When did we enter the order for the Moab?
We were in court last Thursday. It was initial appearance last Thursday, I believe, or
So
Wednesday.
my question to you is this, is that we have an order for protection that does not allow him to go back to the house and that continues to remain in effect,
Yes, sir.
doesn't it?
Yes, sir, 61 days.
Mr. Lopez, you need to understand this because this is very important. This is something that needs to be researched because you're entering into this agreement where you could be possibly let out within the next couple of days. However, there is an order for protection that has been entered. You're not to go back to this location within that period of time. Because if you do, you could be facing an additional violation of protective order. Do you understand?
Yes, I do.
So, life is way too short to live in fear. And it's not fair. It's not fair that anybody should have to live in fear. You know, you have significant criminal history and everything here that you've had here is because of no self-control. What's it going to take to get you to realize that you just can't pop off like that? Is it gonna take a 15, 20-year sentence to get you to realize this the hard way? Consider this when you're out there. If I say this, what's gonna happen? If I do this, what's gonna happen? Because you could very well be a 15 to life case the next time you pick something up. It's not hard. If you get upset, walk away. But please, don't let them live in fear. Life's too short to end up in a 6x9 box for the next 20 years. You understand? It's not fair. Especially someone who's raised you, fed you, clothed you, loved you for 20-something years. It's not fair. Consider that. You're charged with terroristic threat of a family or household member. You've worked out an agreement where they're offering you 50 days in jail with credit for the 9 days that you've done. I'd like there to be an affirmative, okay, there is an affirmative finding of family violence in this case. You need to understand that this is very, very important because another case like this, there's an affirmative finding of family violence in this case, meaning you can never own a gun or ammunition. The other thing you need to realize is that if you pick up another one of these like this, you could be very well facing a 3rd-degree felony. And because of the pen trips, you pick up another 3rd degree, you could be looking at potentially a 5 to life case, maybe 15 to life. So that's what I'm saying. Be careful. Do you understand? They're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. So once you accept this agreement today, there's no turning back. It will go on your record. It's going to be there forever. Like I said, there's an affirmative finding of family violence. So you can never own a gun or ammunition as a result of this plea today. Also, the next one, you could be very well facing many, many years in prison. You understand?
I do.
So you still want to do this? How do you plead to the offense of terroristic threat of a family or household member? I'm going to find you guilty. I'm going to sentence you to the 50 days, give you credit for the 9. Please, just let them be. All right? All right. Good luck, Mr. Lopez. Thank you, counsel. You too.
Also, just a moment.
Hold on. Yes, it was. I signed it.
Absolutely. I only see the motion for the MOAB, not a signed MOAB itself.
I thought it was going.
Your Honor, on Lopez, I just want to bring to your attention, I'm looking at deeds. I only see the state's motion for the MOAB. I don't see it.
I specifically did a MOAB in this case last time. I don't know why it's not
I
signed.
thought it was addressed.
And I don't see it signed in deeds. Because the motion was on the
Signed last
26th.
time I did it the last time we were here in court. The hell, I need a fly swatter. You see that?
Yeah, I think so.
Do you got a fly swatter?
She saw it. No, I don't know.
So I'd like to enter it in then,
Not close to it.
you know? So I'm gonna undo the plea.
Okay.
I'm gonna enter in the MOA and then we'll do the plea again.
Yes, sir.
Because I want to make sure that there's no issues with this family.
Yes, sir.
All right, coming up, Mr. Lopez. So I didn't sign the plea.
There's no entries, nothing.
Okay, so hold on, let me do the MOA first. So I'm entering in what's called a magistrate's order of emergency protection that identifies Ms. Solis as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of the Bower Creek residence. Do you understand?
Yes, I do.
If you violate this, the state can and probably will file a violation of a protective order. This includes you cannot text them, you cannot message them, you cannot use social media to reach out to them, you cannot use, Snapchat, you cannot use someone else to try to get in contact with them. No contact whatsoever. Do you understand?
I do.
This order is good for 61 days from today. So if You go over there, it's gonna be an issue. You understand?
I do.
Okay, so I want to sign first, now the MOA,
Okay.
and then after that, we'll now do the plea again.
It's here too, Judge.
Mr. Lopez, I want to protect every person in my county, and I'm gonna do it at all costs. Do you understand?
I do.
All right, so let's do this plea again. You're now charged again with the offense of terroristic threat or of a family or household member. You're facing up to a year in jail and or a $4,000 fine. They've offered you 50 days in jail, credit for the 9 days that you've done. You're giving up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers if you're not a citizen. There are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. There is an affirmative finding of family violence. How do you plead on this case? Guilty or not guilty?
Guilty.
I'm gonna find you guilty. Now we will sentence you on the case. All right. Good luck to you, Mr. Lopez. Make me proud, man. That's all I'm asking you to do. All right. Yeah, okay.
Judge, I wanted to approach on a fugitive case. I wanted to see if we could bring him out.
Sure.
It's Mr. Cordell Jackson. I'll let the bailiff know right now.
So just have a. Someone else approached on this, did they not yesterday?
We were here last week on this one. I don't know if somebody today or last week.
Another lawyer approached on this case.
Really?
Maybe I'm thinking of another case. What would you like to do?
Judge, I wanted to approach to see if you would reconsider a fugitive bond.
Okay.
Yeah.
Good morning, Mr. Jackson. So, Amy, we spoke about this last week.
Yes, Judge.
I denied him a bond last week.
Yes.
Has anything changed?
No, Judge, it's the last thing for no bond.
Tell me, I don't even remember. What does he want it for?
He's wanted from Broomfield County, Colorado for failure to appear for burglary. It was issued in October of 2023. He's also here in Harris County for evading motor vehicles. He also has other criminal history that we can go into, but it would need to be offline stream.
Okay, I remember that. Okay.
Judge, yes. First, criminal history. I don't know how much we should go into that. We are here.
Don't go into anything that's.
No, just
What we're going to.
it's not something I want to go into anyways. I don't think it's relevant to whether or not he's gonna turn himself into Colorado or not. I think if we focus on that, the argument is that he would like an opportunity to go turn himself into Colorado for this pending case. He hasn't been found guilty out there. He's presumed innocent. He would like the opportunity to go turn himself in. He hasn't messed up in your court before. He hasn't been given that opportunity before. And he is not asking for a PR bond. He's asking for a bond sufficient enough to guarantee that he will go turn himself in over there. He has family members here in court today showing their support for him. He's got 3 family members. After talking with them, they are inclined to help him make a bond as well. They understand the risks. He understands the risks if he doesn't turn himself in over there. He understands the complications of having to meet his court date deadlines. And so we are just asking for you to consider giving him a sufficient bond to go turn himself in.
Who's here? Mom?
Judge, we have his sister, we have Santa, please. We have his sister-in-law, his girlfriend, and his cousin. Sister-in-law, and girlfriend.
Thank you for coming, God. Really, I appreciate you coming. You're welcome to come up if you want.
And these are the family members that would be responsible for helping him post the bond. They would be posting the bond for him, and they understand the risks involved.
Sure. Hi. Thank you for coming. Thank you for coming. Thank you for coming. You know, and I told this to Mr. Jackson about a week and a half ago. There are several things that I look at when I give someone a bond. One of the things I look at is their prior criminal history, what they have done, how old they are, and whether they've left a wake of just destruction in their path. Mr. Jackson is very young. Right, he's what, 20, 22? And in the short time that he's been alive, he's managed to rack up a ton of cases. Just here in Harris County, an evading that was dismissed in 2021, he picked up a felony theft in 24, an evading arrest in 24. He has a fugitive case out of another jurisdiction of another state. And now he picked up here 2 weeks ago, another evading arrest. So the common theme that we have here is I'm going to take off and I'm going to try to evade. That's the common theme that we have. And the two things that I don't want are, number one, I don't want him to pick up another case. And most importantly, I don't want my public to be in danger. These are the things that I consider. What is he wanted for out of state?
Failure to appear for burglary.
And now here's another burglary in another state for failure to appear for that. At what point do we say when? So my point is that the problem is that if I give him a bond and he just takes off, all you guys are going to lose out on all that money. And what happens if he picks up another charge? So these are the things that I consider. And this is why I denied him a bond the first time. It's because what the common theme that we have here is that in the short time that he's been an adult, there's a ton of evading and flight cases. That's why I didn't want to give him a bond. Because in my opinion, he already has 3 flight cases. Do we need a 4th? And that's what scares me. Carter.
Judge, considering all that, considering his family's here, we would be asking for an amount that ensures his attendance in Colorado. I think by putting an amount on his case, it would ensure that he hasn't had this opportunity before. He hasn't had a risk of losing money before. This risk would ensure that he does what's right and turns himself in over there.
But he has, though. You know, he has. He got out in Colorado, failed to appear on that. He's constantly trying to evade, you know, here as well. It's a constant thing. And I can't continue to say, okay, it's okay for you to do this. La, da, 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 da. It's not okay. The bill comes due. Do you understand? At 22, you have all these cases. Life is hard enough as a young Black man in today's society as it is. And now with all this, really? You want a pat on the back for all this? You want me to just, no. Now the bill comes due.
Judge, if I may, respectfully, one of the things that I wanted to do was look into the Colorado system to see if it was actually a failure to appear or if this was a sort of like a 2B warrant here in Texas. I wasn't able to log into that system over there, and I don't think we can make the distinction on whether or not it was a 2B warrant based on the documents that have been filed, or if this is one of those situations where he missed a court date.
Regardless,
Okay.
all we have are someone constantly trying to evade capture. They're trying to evade police one way or the other. I have a feeling if I let him out, the same thing's going to happen, you know, and I don't want that to happen. I don't want you to pick up a 4th case, 5th case. I certainly don't want anyone to be injured. And that's it. At 22, all this baggage, it's not going to happen, man. The bill comes due. I certainly appreciate you guys coming. I know that you've taken a lot out to be here today. It's just too much baggage. I'm sorry. Okay. Thanks, guys.
Thank you, Judge. Thank you for your consideration.
Of course.
First one is an off-docket matter,
Okay.
and the case number,
Hold on.
case number is 2530952. Damilet Wahoricus.
Okay.
Judge, she's charged with the possession of tramadol, no priors. She had $100,
She took off.
what happened, Judge, is,
She here?
no, she's not. So I want.
I'm not gonna reinstate her until she's here.
Will you?
She's gotta be here.
Okay. And I was talking to the state about the lowering the bond. Would you consider lowering it to 500, Judge?
I've never even seen her. We never did it. We never even did arraignment because she just kind of took off, never came, never did anything. I've never even seen her once. Get her here and we can talk.
So,
You know me.
okay, so I just don't want her to get arrested.
No.
No, she got no priors, US citizens, just,
You know me.
okay,
Don't you?
sounds good. I'll bring her, Judge. Second case is on the docket, called Triple G, Gerardo Garza Gascon. Got into boxing.
There's yeah, okay, I got it.
Anyway, we just signed on yesterday. We started looking.
Yes, of course. So we'll just give you normal reset. Normal reset.
Okay, thanks.
Yeah.
Joe. All right, have a good day. And
Thank you, Frank.
have a good day.
Who do you have, Mark?
Badon, B-A-D-O-N. So just about, he tried fixing his license. He went and did all stuff with DPS. He found out he's got a issue out of Sugarland, which he's taking care of. He just needs more time.
Yeah, but I mean, we're at 783 days. At what point do we say when?
But you said 7.
Huh?
But then you said 7.
No, 783
Has to
days.
be even, right, Judge?
Hmm?
There's no way that I've been on for 700 days.
No. You've been on since like February, beginning of February, but I told him that he had 30 days to do whatever he wants to do. But how do I know he's gonna fix the stuff in Sugarland within a reasonable amount of time? You know, like not gonna take 3 months here? No. So we need to figure out where is she here?
He's here. Talk to him and see if it's legal.
So no, what I'm gonna do is, I guess, will you have an offer on this case?
No, but I'm sure they would time serve it.
Well, I'm willing to give a little bit of time, but I'm not gonna go crazy. It's already nearly 800 days old, so I need to get a date. Are you Mr. Badon?
Okay.
Come on up.
How is March 24? Too soon? No, it's a little bit more.
I'm willing to give you a little bit of time for you to try to fix your license. But your case is nearly 800 days old. It would be unreasonable for me to let you just sit here 3 months, 6 months. So we need to put a time limit on this by what day you need to have this done by.
I paid my surcharges already. I just need to start a payment plan with Sugarland and that's it.
Okay, but when is this gonna happen? If you even do that, will that lift the ineligibility of the license anyways? Do you know?
Yes.
You've reached out to
I talked
DPS?
them already, yeah. Yes, sir.
Okay, I don't want to know, but we need to put a date certain when the last day for this case ends, where you either get done what you need to get done, or you end up taking something on this case. But I'm not gonna just hold this open indefinitely, even considering that it's 800 days old nearly. So, Alex, is there an offer on this case?
These are 2 PTI offers, Your Honor, and both of them are contingent upon the driver's license being valid.
Okay, so you reached out to DPS.
Yes, sir.
They've told you what you need to do to get it
Yes,
fixed.
sir.
Okay, I'm going to give you 3 weeks. You get no more time after this time. Do you understand? At 3 weeks, it's D-Day. If it's not done, then we need to move on. But yeah, I'm gonna either set your case for trial, or you gotta accept the plea bargain agreement. Do you understand?
Yes, sir.
So, Marco, this is the last reset that I'm doing. I'm not doing any more. You need to do what you need to do today, because it takes forever for stuff to reflect in DPS's system. That's why I'm giving you the 3 weeks, because you need to take care of it today. Because if you wait till the last minute, it's not gonna reflect in DPS's system. It takes 2 weeks for them to just upload stuff to get it changed in the system. You understand? Okay.
Thank you, Judge. Appreciate it.
Judge, how much time like that?
3 weeks and then clear trial, the next setting.
Judge, I have
Okay.
Moses Garza.
Mr. Garza, come up. Are you sure that you want to do this? You know, the thing is this, Mr. Garza, you're going to pay for it one way or the other.
That's what one way or another, I know I'm gonna have to pay for it. It could be, this sound bad, but
Problem is that
trial's gonna make it
this,
worse.
when it goes on your record of what you're doing today, it will hose you in many facets of life. Your insurance is gonna go up. It could affect potential employment. So DPS is gonna hit you. It just, whereas with this route, if you're able to do the PTI route, you know, you can get some stuff waived, but at the end, if you complete it successfully, the case gets dismissed. Once you plead to this case, there's no turning around. And we've got a fly swatter. We got a fly swatter.
And the thing is, the fly is huge.
Judge, you were a defense attorney at one point in time. You know this is probably gonna be the best deal, to be honest with you.
I can't give you legal advice,
No,
right? That's why we gave you a lawyer.
And Judge, the issue with the PTI has been the financial aspect of it.
Here.
Yeah.
It's right there.
Sorry.
We've talked about the PTI and he just says he can't afford it. And so that was kind of my recommendation.
Gonna
was
get hit.
The PTI, if you can afford it.
Yeah, one way or another, it's
How much can you waive, Blaze? Guys, on a PTI, DWI, how much can you waive as far as fees and stuff?
My understanding, the only thing that can waive is the DAO fee, Judge.
On PTI, I think you would have to go, they'd have to get special permission. My guess would be through a division chief. I think they could work with defendants.
And Your Honor, another issue is that his license is not eligible, so he'd have to also pay the fines associated with correcting that before.
Well, he could do the no driving
License is
affidavit
suspended?
It's currently, yes.
Oh, okay.
of the ALR, but you can probably do the no
Probably.
driving affidavit and stuff.
We'd also have to reach out to the GBO.
Yeah, and I don't know kind of I think that they can work with them on it. So if
Counsel,
counsel
what
reach
was that?
out to Ashley and see like what.
Will they pay for alcohol monitoring device, Judge? I don't think they'll do that.
That, I don't think so.
Right.
So the one fee I know that you'll probably have to pay is the interlock fee, which is the breath test device fee. That's usually around $70 a month. Can you swing that? Are you working?
Yeah, I'm working, but on top of everything else.
And he pays child support right now, Judge.
That too.
I mean, if I could pay for it, I would. I just can't. I mean, do you want time to think about it or you want to, look, why don't you guys step aside, just make sure this is what you want to do. If you want to do it today, I'm happy to do it. If not, I can give you more time where you can, talk with the division chief to see what you guys can do to reduce the fees,
Okay.
It's up to you, but I don't want you to make a decision in front of everybody here. Just take your time. Just
And talk
know,
about that, Judge.
because once you do this, there's no turning around. That's it.
Thank you, Judge.
Please, just take 5 minutes. Hi, Counsel. Of course.
One time, good to see you.
Hey, what's up?
Judge, I'm standing in for John Paul Cedillo this morning on
Okay, yeah.
Dasaki, DASSAKE.
Okay,
Judge, so by way of context, note here from John Paul saying that the client was attempting to apply for PTI. Mindful that this is now
yeah, we've been working on mitigation since,
180 days by my count.
well, since December.
Yeah.
Is this person here?
No, appearance is waived for today.
Let's do this.
Yeah.
I'm gonna give you 2 weeks. The
Okay.
defendant must be here with packet in hand and let them know that if they're not, I'm gonna carry them day for day till they get the packet done.
Got it, Judge.
Yeah?
Yeah,
Okay,
sounds good. Maybe excuse. Good seeing you.
you got it. You too?
There you go.
Thank you.
Counsel,
Mr. Madrid.
that-
Yes, good morning.
Hey, good morning.
I'm approaching, let me make sure I have the right case I'm telling you. But the other day I approached to move this case from, well, actually I was on the phone, I think, on
On
Zoom.
trial or something like that?
Still in trial.
Okay,
And he's on the docket tomorrow. I think we're gonna be done, move it to Friday.
sure. How about Monday?
They do it a week from Monday because it's spring. No, I could do it Monday. I'm gonna be here. Okay,
Wonderful.
then we'll do
Happy to
it.
have you.
Right.
I'm gonna get that damn fly. I'll tell you what.
Not as big.
We'll do it Monday.
Yes.
No, I'll let her.
Where is it? You see it?
It only comes whenever you're ready for.
It's a big one too. Like I'm gonna knock over coffee and.
What's the last thing?
Hi, Dave.
It's never, hey, we have tacos. It's always, hey, there's a constitutional issue.
Hello, Judge.
Here.
We're here on Roderick Bolton.
Okay.
This was on the docket Monday and,
Was on the docket.
yeah, it was on the docket Monday,
Okay.
on the docket today. You want case number?
Sure.
It's 2551-572. We originally, I was assigned to represent him on February the 17th, and he had already executed a waiver. He had a local case that's pending in court number 2, which the court granted him a PR bond on February 14th.
You guys notified the remaining jurisdiction?
So this one.
Well, this is kind of unusual.
Okay.
We were reset until Monday because that would have been the 14-day time period. For some odd reason, even though the bond, which I want to tender to you, local case was signed by the judge, defendant, and everybody on February the 14th. And it was entered on February the 15th. For some odd reason, the sheriff's office didn't
just the last one.
book the hold off of him for the local case until February the 28th.
Julie Salgado, it was.
Are you saying they didn't see the release of the hold until the 28th?
No, it wasn't made until the 28th, but it wasn't remitted to the sheriff's office until March 3rd, according to Ray. So it was set on, bond was set on the 21st, but it wasn't made until the 28th, remitted on the 3rd. For the local case, not for the fugitive case. Sorry, for the
local case, bond was signed by the defendant, the magistrate, and
On the February 14th. So the hold, so the 14 days starts running that day.
That's what I said.
I don't have the.
This is Christie, she's the attorney representing the local case.
Yes, and I think there was an issue with the spin numbers too, but I don't know if that was.
There was a spin consolidation. That was a separate.
Oh, okay.
hold. So that would have held regardless, but I'm gonna need Ray's side on that part, because I was asking most of the questions regarding that.
Where's he won from anyways? Is somewhere
Oklahoma,
Oklahoma for.
Ottawa,
Yep.
Ottawa County.
I mean, unless you have like a pre-signed waiver or, you know, carries a life term.
First degree robbery, I don't know. I can do a quick check.
I mean, he shouldn't be held to pay for the mistake of someone else.
Let's see, that one is not less than 10 years, so 10 is the floor. What is?
I'm with you, Carl. I'm not gonna let him pay for someone else's mistake, you know?
So the fugitive is dismissed.
Well, I don't know. If he decides not to, then I'll just give him a PR bond.
Okay.
Well, no, I mean, in terms of, so.
Or how do you want to handle it, Dave?
Hold on. Actually, the other thing I tasked Amy is to contact the demanding jurisdiction to figure out when they would be able to come.
I'm still waiting on a response from the defendant.
I mean, because we still have a couple days regardless, right?
Right.
Well,
So-
he's in court today on the misdemeanor, which was reset until March the 18th, 17th.
Regardless, though, they still have a couple days for the 14 days, or is the 14 day today?
The 14 days would have been up March 3rd.
If you're going all the way back to the 15th, sure, but I contend that he
It's
did.
over.
I contend that he didn't make it until the 28th, because there's still the spin consolidation even before the leasehold, so.
Now, he made the bond on February the 14th. The sheriff's office, that's on them. They didn't do whatever they were supposed to do until March the 3rd or February 28th or whatever dates are
They didn't do
relevant.
anything wrong, they never got the information, so they didn't do anything wrong because they didn't get the paper.
So is the district clerk's office then?
They're right. He's right there. So it's the one that we talked about regarding the hold, figuring out what the hold issue was, but I don't know to the contents of it, just that the sheriff's office didn't have it. So
Regardless, I can't,
yeah.
I'm not gonna let him pay for someone else's mistake, whoever. It doesn't matter who it is.
No, but I'm saying, even assuming going back for the dates that he had after he made the bond, is there was still a spins consolidation hold, which is different, because that's not case specific, but I don't know the answer to that.
No, right?
He's in court number 2.
I'd like to talk to him.
Can the buddies bring him up
Because
to?
what I'd like to do is admonish him to let him know that
Very confused.
we're gonna release you, but that warrant is out there and it's always gonna be out there, and they can go and get a hold here tomorrow or later today.
Does live there. He was just here for.
So if you release him on bond, Judge, does he have 14 days to go up there to get the?
No, he's released. He can do it.
Do you need to run down to court too?
He'll always be there.
Okay, you want to come, you want to.
He could theoretically call them and they could issue a new one right now before he's even released.
Sorry, so this, in the condition that he is released, Judge, you typically give them an opportunity to respond in lieu of them not coming. If it's a matter of just, of the court admonishing.
I was gonna admonish the defendant and go, look, you know, I'm giving you a PR bond, right? Because there was a mix up.
But for the PR bond, that would necessitate a reset for a future date, which is why I'm bringing up the question. If it's an admonishment for him to return, still needs a set date.
Yeah.
For robbery.
That's right.
That's what I was asking.
Right.
But that being said, I'm double checking because it's a floor of 10 for first degree robbery. If it's life, then he is not eligible, which is what I'm still checking.
When someone gets a charge and it carries a term of life, I'm not allowed to give them a bond, no matter what.
True.
So, but I can't imagine on a first degree robbery, it's gonna be.
I mean, for our first degrees, we have 5 to life, so assuming that Oklahoma is similar, then.
Well, that's
That's
true.
what I'm checking, I don't know. Yeah, well, I mean.
Well, there's
this is-
different degrees of robbery in the state of Texas.
This one's first degree though. This one it says on the teletype. But AI, Google AI, however reliable that is, does say life, but let me double check though. I don't want to misspeak.
You speak Okie?
Not well. Not well.
I don't think that, they can't read and write up there anyway.
208.
You mean talking about sinners.
Robbery, 2 or more persons of felony. Attempted robbery with
10 years.
I'm sorry?
I got 10 years, but I don't know, it
No,
could be
it's,
wrong too.
well, not less than 10 years, but it doesn't show the maximum.
Just a minimum?
Just a minimum. Well, some states just do that where there's just a minimum and obviously there's no ceiling. With the exception of.
Yeah, I see what you said. There's no max, which is really weird, right? It's like.
It is, but it's not the first penal code that I've seen that does it that way. But I interpret that as life in prison. If you want me to double check, I can call the ADs there if they interpret that in life in prison. If they do, obviously it's involved.
How can you possibly interpret that as a life?
Oh, like I said, I can call the DA's office there and double check. Fine. That's why I wanna, if I may have a few minutes to stand down, I can call the DA's office up there. I'll do that right now.
Judge, did you?
Any way you want it, do you want him up here, Judge? One way or
They are
another?
gonna Start picking a jury at 11 is what I was told in court too.
Is there any way we could get him, you think?
I will.
Deputy, he's in court 8. Can we get Roderick Bolton? He's down in court number 2.
Is it possible to get someone who's in court too? Please, Bolton. Do you mind giving him the cause number and maybe he can?
And Judge.
Sure.
I'll call simultaneously, see if I can.
Do it.
Thank you, Judge.
Thank you, Your Honor.
Yeah, of course. Arraignment. Let me do this real quick with Mr. Are you ready? Yes. Okay, let me do this for you real quick and then we'll. Mr. Craig, come on up. All right.
Counsel for reset?
You know, you were really given a gift in these cases. Really. I hope that you realize this and understand this because there's not many times that you're going to end up with what you've end up with where you're not doing years in jail. Really. So there are certain people in life that are a cancer to you. If you don't cut it out, it's going to kill you. I know that you have a child with this person, but if you just can't stop butting heads, you need to go away because it's going to end up killing you, man. If you haven't realized by now, what's it going to take? A 10-year sentence? Life is way too short to end up in a box like that because of one person. Do you understand, Mr. Craig?
Yes, sir.
Don't let someone kill you because that's what's happening now. With us, you were placed on probation for a violation of protective order. You picked up another protective order. And the agreement that you guys have worked out is a global resolution where he pled to the felony case, right? That was basically time served. Is that what it was?
Yes.
They're going to dismiss one of the violation of protective order. However, you need to understand that on the probation case, I am now finding that you have violated this probation. This is going to go on your record. Do you understand?
Yes, sir.
I am going to sentence you to 1 year in jail. I will give you credit for the 232 days that you've done, but you have to understand that if you continue with the same course of conduct, it's very possible they hit you with another third-degree felony. So be very, very careful how you carry yourself for the next year or two, because a continuous will really land you in hot water. You understand?
Yes, sir.
So it says here that you had the prior assault on June 1st, 2024. Is that true or untrue, sir?
True.
I'm going to find that as true. I'm now going to revoke your probation. It will now reflect as a conviction on your record. I'm going to send you to the 1 year in jail. This is the one that was upstairs, right? So that one's already been taken care of. So it's not going to like hurt him now. Right. Okay. That's the reason I'm wanted to do this now, so that it doesn't hurt you in the future. You hold the keys to the cell. No one else does. I'm going to roll your court costs so you won't owe anything. Good luck to you, Mr. Craig. Thank you. Okay. Thank you, Mr. All right. Take care, guys.
Mr. Craig. Larsa, I don't know. We're gonna get to the first order collections on the form and then we're gonna.
All right, page 2, Andrew, come on up.
Good morning, Ms. Saunders. Hi, good morning. Ma'am, you are charged with theft. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am.
Yes, Judge. On January 28th, 2025, at approximately 11:21 a.m., the officer was dispatched to a theft call at a Walmart in Harris County, Texas, where the officer made contact with the complainant, an asset protection employee, who stated she saw the defendant on surveillance enter the business, place several items inside a shopping cart, then proceed to self-checkout, where she skip-scanned items. The defendant passed all points of sale without attempting to pay and was subsequently detained by asset protection. The total value is $115.74, and the defendant stated to officers that she is currently employed, but times are hard.
Okay, Ms. Andrews, I'm going to find that there's sufficient probable cause to go forward with the case. I am now ordering you as a condition of your bond not to go to any Walmart. Do you understand? Yes or no?
Yes, sir.
If I find that you go back to Walmart or you pick up a new case, I will revoke your bond, put you in jail. No more PR bonds. Do you understand? Okay. Do you have the ability to hire a lawyer, or would you like to apply for a court-appointed lawyer?
Appointed law.
Okay. I need you to fill out an application for me. Deputy Miranda is going to give you an application. I'm going to have you sign a reset with Victoria. I will have you take a seat in the jury box while I find your lawyer. Do not leave until you sign our bond conditions, though. Okay? All right, please.
There's a Spanish arraignment, so the council's hearing.
Okay. Hey, so can you file me going to Walmart? Thanks.
Page 2, I'm sorry, 22, Navarro.
Okay.
Navarro, come on up. Right next to me.
Are you a lawyer, ma'am?
I am.
Are you representing him?
Yes, I am.
Because I have here and Mr. Garcia that's
Yes, I'm a non-primary attorney. I sent the letter of representation last night.
Oh, okay.
They're both in Dean's, Judge.
Yes, Judge, they filed, that one.
Do you work together or you don't work with this person? So we,
I've worked with Eduardo, yes. I help him out.
got it. Okay. You are Saul Navarro. Mr. Navarro, you were charged with driving while intoxicated. You are facing up to 6 months in jail and or a $2,000 fine. You're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On February 2nd, 2025, at approximately 1:50 a.m., the officer was dispatched to a call about a vehicle parked occupying both lanes of travel. Upon arrival, the officer observed the vehicle parked in the roadway occupying both lanes of travel. The officer observed the defendant sleeping in the driver's seat of the vehicle, and the officer opened the door to wake the defendant up and observed bloodshot, red glossy eyes, and standard field sobriety tests were then conducted. The defendant could not complete the HGN for walk and turn 4 out of 8, one leg stand 2 out of 4. The DIC was read and the defendant refused to provide a specimen. A blood warrant was signed and executed.
Look to see if he had moved prior to DWIs, please.
He had no priors, Your Honor, and I'll run his license.
Please. Mr. Navarro, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I will revoke your bond and I'm going to put you in jail. I don't know what your immigration status is, but if you're not in this country with permission and you go to jail and immigration finds you, it's very possible that they put an immigration detainer on you. And if that happens, you will be stuck like Chuck in custody until this case is over with and then shipped off to immigration.
He has no license on file.
If you do not have a Texas driver license, you are not allowed to drive. I am making that a condition of your bond. You will be signing a promise with me today, Mr. Navarro. This is an affidavit that you're not going to drive. I do not care what is going on in your life. You cannot justify getting into a car for any reason. I don't care if there's a burning building and you have to save 50 babies. No driving. Do you understand?
Yes.
Now, good job on having a lawyer. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with them. If they tell me they cannot get a hold of you because you're ducking and dodging and not responding to phone calls, text messages, I will issue a warrant for your arrest. I want my streets safe and I will do everything to protect us. If that means putting you in custody, I will do it in a heartbeat. For now, I will have you come up here, swear to us that you're not going to drive. I will get you to Victoria where we will have you sign a reset. You will then get with Felicia for your bond conditions, and then after that, you're free to go. Thank you. That's it.
Judge, did you go, I think went to law school. Did you go to school in Michigan? Okay.
I am here this morning on Mr. Booker. And as it turns out, Judge, I believe we're going to need to request a trial date.
Okay.
I don't know where you're.
Work out in the other county.
Judge, the state has offered to defer despite the fact that my client is PCI eligible in Harris County. I have been unable to.
You do not have an open one in another county though?
He's already on PTI. I provided the state all of the paperwork and they will not.
I think that's
It would be against our policy to offer him another PTI.
right. I mean, I think it's like, but yeah, if you would set up a trial, yeah, whatever date. I mean, with, 30 days.
But he is going to be on active orders the entire month of April. That's why I'm not sure what your trial schedule dates are right now, like how far back trial is. April.
You do 30 days out.
Okay, he will be the month of April, and we don't know when his release is. He reports on March 17th. And he's here, if you'd like to confirm me this. He reports on the 17th. And he knows that right now he will be gone the entire month of April, but when he'll be released from active orders, he does not know yet. He won't know until March 17th.
Okay, so.
We
have
could-
May 6th, Judge.
Something in May would be ideal, yes.
Yeah, but I want to know for sure. So why don't we set this for, you said March 17th is he?
March 17th, he should know he's
So-
there from the 17th to the 20th. He'll
So let's
be,
set it for that day. Let's set it for the 18th.
he won't be able to be here, Judge. He'll be with his unit.
That's okay.
Okay, as long as I'm here. Perfect. So
Come in, find out what his schedule is, but I want to, he's got an open DWI somewhere else. This case is rolled, right?
he's already on PTI on that DWI.
I get it, but that doesn't. What's the last name again?
Booker?
Booker. Yeah, it's 220 days old. I mean, we needs to be set for
And
trial
Judge,
yesterday.
so you know, I did not receive any camera evidence until 5 months and 2 days into this case. I was unable
Come
to
to me
apply
next
for
time.
PTI.
I'm happy to do it at any time. You know, at 4 months, if you've not gotten anything, 3 months, come to me and I'll, I do it all the time. I make them
I know.
discovery here, really.
And we still have no station video. They said there is not one.
Well, that's something different. If they don't have it, they don't have it. But if something
I
is,
just wanted the court to understand, I was unable to apply for PTI because I did not have my evidence and to even make a
That's okay.
decision on the case.
so let's set it for the 18th.
Okay, would that be a
Come back.
call conference? What do we want to call?
No. Just, I want to know what day we can actually set it.
Okay,
So
perfect.
you come back on the 18th, we'll have a schedule. We can set it for the first week of May. And then we'll have a pre-trial conference 2 weeks prior to that.
Okay, Judge, thank you.
Okay. Ray, the man, the myth. You, come on.
Oh, sorry, I forgot your live stream.
What's up?
Mr. Gomez, you might recall Mr. Gomez tested positive for cocaine last month.
Okay.
You placed him into custody. He's a DWI.
Still there?
Yeah, he's got an ICE hold. Yeah, so he's not gonna
What do you
be
want to do?
set for trial.
Do it.
We've
Whatever
got,
day you want.
yeah, we've got nothing to lose by going to trial. He's gonna get deported regardless, so might as well.
Whatever you want to do.
Sounds good. Thank you, Judge.
Thanks.
Judge,
Carl.
which case is this on?
Gomez in custody, whatever Ray wants. Hey, it's got to be at least 30 days though. At least 30 days, but then whatever you want. Okay, Carl. Oh.
He's,
Mr.
Bolton's in the back.
Oh, please. So,
His life. I talked to an admin who had the ADA and it was almost speakerphone. I could hear her in the back, so his life.
couldn't see it in the statute.
I asked if there was a separate punishment, but they understood that as floor minimum 10, and because there's no cap, on the statute, that's how they have it. So I didn't, at that point, I just wanted to make sure to get back before y'all approach, so I didn't ask what other statute would govern, but that's how I have it. I should have asked what Oklahoma specific penal code, but at that point.
Because that's what I'd like to see, because I didn't see a max there unless they have, and you know how wonky the statutes are, it's like.
That's true, we have some fun ones ourselves.
Clear as mud.
Right.
And I think Amy is checking to see if they can expedite their,
Right.
pickup date.
So trying to get it taken care of on all fronts.
Good morning, Mr. Bolton. I wanted to bring you here because there's a lot of things that you need to understand what's going on. You're wanted out of another state, Oklahoma, specifically for first-degree robbery.
Yes, sir.
And there are certain times that I can give someone a bond, and then there are certain times that I cannot give someone a bond. Typically, I can in almost all situations, except for number one, where someone signs what's called a pre-signed waiver. Let's say you get on probation in Oklahoma for a case, right? One of the conditions that you sign, you say, I agree to waive extradition in the event I ever become a fugitive. So if you take off, you become a fugitive, you can't try to get a bond because you've already, in essence, waived by getting onto the probation. The other instance is when there is a charge where it carries a term of life in prison.
This one's a first degree robbery, Your Honor. It has a minimum 10 years prison up to life in prison. So because the punishment range extends to life in prison is it states contention that he is ineligible for bond.
Response, you have any?
The response is the statute that you read has no ceiling. And it doesn't state, the
Let's do
statute
this.
doesn't state the ceiling's
I don't
life.
want to do something wrong, so I'm not going to set a bond now. Do, any kind of research that you may. If you find something different, let me know. I'm all ears. If you find something contrary to that, I'm always willing to listen. And then if so, I will. The problem is in your cases, typically we give other jurisdictions 14 days to come get you. In this case, someone somewhere dropped the ball where they didn't give sheriff's office notice to call Oklahoma to say, hey man, come get him. So Oklahoma really never even knew to come get you, right?
Till Monday, March 3rd.
So the 14 days ran on the 3rd with, now it's the 5th. So that's why there was this little snafu where I was going to give you a bond today. And I was ready to until they said that this now carries a term of life. So I can't. That's where we're at. So I'll have them do research to see if there's something different. If there is, then I'm all ears and we'll go from there. In the interim, we don't want you to just sit there and languish. So Mr. Kim is going to talk to Oklahoma to see how fast they can get here to come pick you up, to take you back. You need to understand one more thing is that you were on bond for a case in here. You need to stay in contact with your lawyer here, because if you don't, and you get up to Oklahoma, and for some reason the bond gets forfeited or revoked here, the situation you're here, it's going to happen over there in Oklahoma. So you'll be back over there, but then Harris County is going to get a hold on you here. So make sure you stay in contact with the lawyer so they know exactly what's going on at all times, so as to not something bad happen to your boss.
Okay.
Do you understand? I wanted to bring you here just to give you a heads up so you know, I mean, these are your cases. You need to know what's going on. It's only fair. So if you have any questions, I'll direct you to your lawyers here and they can answer anything that you may have.
So Amy just said, just talk to them. They can be here by the 17th, so we'll meet the deadline by the 18th. So they will be here the day before the next court setting here.
Okay? They'll be here the 17th to come get you.
Thank you, Judge.
So just, I guess, whatever you can on your case there, because it could impact. Yeah.
Okay.
Thank you, Judge.
Thanks, Carl.
I'll find anything different, I'll let you know.
Just let me know. I'm all ears, always. Yeah, of course. Come, talk to me. Hi, Mr. Brooker.
Judge Gregory Hines, initially I was walking up here to set this case for trial, but the state put another offer in there that I need to strongly suggest Mr. Hines accept, which is a PTI. Originally, it was a
But
deferred.
he never even wanted a PTI.
He didn't want it deferred.
And I think he can't, you said like, I don't even think he'll take a PTI.
I didn't, but I haven't offered it to him. I talked to him about what deferred was and what the conditions were. It's not too bad, Judge, but it's getting close.
I mean, it's 200 days. So I'll give you till Monday.
Okay.
What did you offer?
It's 4 hours anger management, 8 hours.
Okay.
And Judge, he lives in New Orleans, so would you mind if he is waived Monday? We'll make the decision this week, let you know Monday what we're gonna do.
Yeah.
Okay.
If he wants to accept it Monday, we'll give him like 2 weeks to get it done. And then otherwise, yeah.
Sounds good.
Okay.
Thank you for letting me know, because I didn't know. All right, have a good one.
Yeah.
Judge.
How are you, man?
Oh, good. Good to see you, Judge. I was approaching on Mr. Phil Detterville on today's docket. Mr.
You picked up a
Detterville.
new case?
Well, no, he's been sitting in jail for quite a long time. He's had felonies pending.
Oh, I didn't know. What?
And so we were just.
You picked up a felony?
He's had felonies pending in the, in Harris County for quite a while. He has about 114 days credit. Long story short.
That's not his.
And again, I think in talking with the felony.
Really weird because I know him and I don't see that in him.
And interesting, Judge, that's, I think, what the defense attorney in the felony case has proposed. So there's some issues with the felonies. However, he was willing to resolve the case today. The plea offer right now in the felony is TDC time. He's willing to resolve this case today. It's not pleading to any of the allegations in the allegations in the felony are not listed in the MHA.
I think that regardless, we're not gonna be able to do anything, because it's just way too much stuff up there.
From him or.
Yeah, just unset for me. It's Mr. Dito, just if for some magically delicious reason, like he's done and he's back on the street, let him know. If he continues to pick up the trespasses, the exact same thing.
Thank you for caring.
No more, just revolving door. Yeah, okay, well, it's that time. Okay. Mr. Johnson, right?
Very brief, I'll talk about it.
Okay,
I'm sure, cause 254-8089-90. Do the state real quick, I'm just gonna have to travel. 254-8089.
July.
So he's got, randoms. Works with a construction crew. They got a job in Lake Charles, from Monday, the 10th to, April the 13th. He's got his interlock. He can take it with him, not a problem. He just, if he gets called.
If he gets called on, he has to go to a
Quest
Quest.
Diagnostics, is what I told him.
And then we'll waive the signature.
Thank you, Judge.
Okay. Ready?
Yes, sir.
Hey. That thing's still open. Man.
Judge, so, he was here, I think he's in the hallway, but, Judge, he has two Mandel cases that are 15 to life.
I know, all that stuff, what do you want to do here?
They don't want to dismiss it, so, they wanted to set it. So we can set it, it's just,
I get
it's a
it.
constant thing, they don't want to.
Whatever day you want.
So thank you, Judge.
Yeah. Do they have offers upstairs or no? Hey, ready? Hey, what's going on?
Judge, I'm here, Mr. Abear, HEB.
Okay. Oh, it's old. Ay, ay, ay. Ruben, what do you want to do?
Judge, I'm okay with, if you give us a trial date. They just gave us an offer today, a reduction from DWI, 2 to a DWI 1. And, you know, I was talking to them, you know, basically getting emotional. I'm out next week, so I just was wondering if I can get a 2 or 3 week reset, allow them to think on it.
Do you want to do a plea or do you want to do a trial?
To think on it. So that.
But it's 240 days, 3
That's why I
weeks.
said it's okay if you want us to give us a trial date and if we're able.
No, but I don't want to set for trial unless you really want to go to trial. I mean, you want it Monday to think?
I'm out next week. That's why I'm asking for the extra time.
Counselor, who's your client? Quick.
HCP. HCPE.
Okay, thank you.
Okay, is he here now?
Yes.
You can't zoom in? Because I have Zoom too.
Please, no, if you decide.
No, not for a plea, just to let me know if you want a plea.
Oh, okay, and then give a plea date? Yeah, I could do that. You just wanted to come in?
Pick a day next week.
Okay.
Let me know if you want to do some trial or if you want to do the plea, and then I'll give you a date. It's not going to be far, but I'll give you a date.
Got this.
Pick a day next week, whatever you want.
All right.
Any day but Friday.
All right.
Antonio. Ready?
Judge,
¿Qué onda?
you remember Rodrigo Hernandez? He's the one that, he's in the hospital. He's like,
Yeah, okay, I do. He was like, you showed me the picture and he was all.
he's in ICU and.
Yeah.
So,
What's going on with him?
well, they transferred him to a different unit, Judge, and I have what,
Is he still in the hospital?
not the hospital, well, they transferred him to a different unit. I'm not sure.
Like hospice or something?
This is-
Yeah, but he must be out though. If he's out, we need him here, you know? I know that you need further evaluation, but.
Judge, according to his family, he's like a vegetable, you know?
But we still gotta do something with it though.
I understand. But if he's not mentally competent to stand trial or anything, then what are we gonna do?
I mean, if you can give them proof, maybe that'll help, you know? If you can somehow get proof that he's in that kind of mental state, and he's not.
It even says memory deficit, you know?
Well, I forget things. Yeah. Selective memory. No, I'm serious, Antonio, but if you can probably show Blake, we've got great prosecutors here. If you show that he's in that, like mindset and he's incapable of recovering, you know?
Thank you, Judge.
Hey. What's up?
Just one of those days, man, you know, good to see you too.
It's been a while.
The beard is filling in there.
Where are you working?
You know, right now we're on floor 11 for Mac and I do miss felonies too, but I like to do.
No. There's too much drama upstairs. You know,
Sometimes it's like.
I know. I know.
Anyway, so I got Garcia Ibarra, first name Eduardo. He's on your docket. His appearance was waived today.
Wait a second. Garcia number. Oh, I see it. Okay.
I have a motion.
Wait a second. I have Dan on it.
I'm moving sub on file.
I'm subbing in.
Yes, sir. And that's why I'm approaching, because it's old.
Right.
And I just need one reset to look at it.
But it's 184 days. I'll give you 30, but, and then, do you have an offer on the case?
I'm gonna pull it up, I'm gonna ask Mackenzie.
Please.
Ibarra.
Oh, also my motion to sub, Your Honor, hasn't been signed yet. That's part of
Yeah,
it.
it's been pushed through now, Judge.
Okay, I'll sign it now.
Thanks, Judge.
And then, you know, I have one if you need one to sign too.
We do not have an offer on Ibarra, Judge.
You might.
Yes.
We will forego the apology. Dismissal alone is enough for me, just so you know.
Okay.
Okay.
That's all you, friend.
Thanks, Judge. I appreciate it.
Hey, you ready? Abel. So.
Garrett?
Garrett.
Yes, sir.
Terroristic threat
Right.
against allegedly mom.
Okay.
Could have been an assault. Not.
My aunt had, she'd be my uncle.
No, but according to what I was reading here, you know, he's lucky that it's not filed as an assault. And the thing is that, do we let him go home? What's gonna happen? No, because come up, Mr. Garrett. When I have these types of cases normally, I don't let the people go back. Because. Or do you want to talk first and then you come?
Judge, can we step down?
Oh, yeah.
And if you can, Judge, we'll be available at noon to speak, so if we can hold off until noon, I can talk to you.
So, Mac. So, does she want him back? If she wants him back, under what parameters? What rules do you want? You know, give her your phone number, so if he starts acting a fool, she's got a hotline to you, and we'll take care of business. But, I mean, from what I saw and what read, I mean, it could have been filed as an assault.
Yeah,
No?
absolutely. All right, thank you, Judge.
So you're.
No, she's not available until noon.
Y por favor,
so
responder a los mensajes.
That's fine.
¿Tienes preguntas?
You want to sit there, noon, Judge?
No, not really, but, because I don't want to make you wait. But at the same time, I mean, I have a feeling, I know what I think that she's gonna say, but I want to know that she knows that she's protected.
Right, I speaking to him, that's the case. But I had him wait outside. Oh, because I was gonna talk to the DA first.
Okay, do what you need to do, and then I'll have you mention, and then, yeah, come on up.
Here?
So the first thing I told Mr. Garrett is that he's not to use any illegal substances and that you're going to get tested. I want you to know now that I will test you 40 days to 45 days from today. If I find that you're using anything illegal, including THC, I will revoke your bond and put you in jail. Do you understand?
Yes, sir.
Okay. When I have these types of cases, I typically prevent the person here to have any contact with or to go back to the house where the complaining witness lives. Does he currently live there now?
He does, Judge.
It's going to be a problem. So how, because what the last thing I want, Mr. Garrett, are more words to exchange and you end up with another case because there's now bad blood between you two. That's the last thing I want. So how do we prevent that from happening, Abe? What do we do?
Judge, I request that the court order no harmful injurious contact with the CW. Based on my reading of the case, it doesn't appear that a no contact order is required or warranted at this point, Judge.
From what I read, it could have been an assault that you could have been charged with in addition to this case here. What do you think? Say.
Our state would request, I mean, we've got a call scheduled to plan anything. State would request some sort of cooling off periods, right? There would be no contact order, very dangerous cases. We usually have very cooling off periods since these aren't fresh charges.
Do we put him on the street though? Because essentially that's what's going to happen. He's 22, right?
Yes, sir.
Yeah.
We can also, I mean, hold off till it's just at noon.
Yeah.
If it would be okay with the court, I know it's be later in the day till noon.
Judge, she's at the hospital. I don't know if she let y'all know that that's where she was.
No,
She's at the hospital right now, so that's.
Why?
I didn't ask you.
How do you know that she's in the hospital? Figure out, I guess.
Let's reapproach.
So.
It is up now.
Are you done? Do you have anything else to do?
The reason I came back.
So, for now, let's do this. I'm gonna allow him to go back. You guys get a hold of her. If for some reason she says that she doesn't want him back, let me know. I'll get in contact with him and then I'm gonna modify the order so that he can't go back to the house. I'm gonna assume because of the relationship, right? And I don't want to put him on the street, but if she doesn't want him back, then obviously I want to follow the complaining witness's wishes. That's what I always want to do. I don't know if she wants you back. If she does, okay. If she doesn't, but be that as it may, self-control. Because I find that you are mistreating this person, threatening, abusive in any way. And I'm going to tell you now that conduct in and of itself can violate this court order. If I go like this, is that threatening or harassing? It most certainly is, and it'll land your ass in jail. You think it's funny?
No,
Just wait till you get behind and you'll see. I'm trying to tell you that exercise self-control because I will protect every person. And if I find that you become an issue to her, it's not going to go well for you. I will test you 40 days from today. If you test positive for dope, it's not going to go well for you. Do you understand?
Yes, sir.
Okay.
Your Honor, I will let the defendant has been smirking.
I know.
The state's concerned that he's not taking this seriously. Sorry, Your Honor. It's just-
I get it. I get it. Well, he's on notice of what he can and can't do. And the problem is that there are a lot of people on a very fixed income. And I'm going to tell you now that the complaining witness in this case, she's on a fixed income. So you go to jail with a $5,000 to $10,000 bond. Just please admonish him accordingly. Okay. So don't worry about filing conditions because it'll be with Felicia. Okay. Oh, no, Felicia.
Yes.
No weapons as well, please. Jaylee.
Honor, how are you?
Hey, what's up?
I have Edward Trevino.
Okay.
And Your Honor, he is autistic. I would say probably moderate to severe autistic. And his father, the day I got appointed, his father was here. He lives with parents.
I remember.
You probably do. And so I've been, father keeps telling me I need to get this dismissed because it's autistic. And I'm like, okay, I'm trying. And
bring him here and I'll talk to
that's
them.
what I was gonna say.
Bring him here,
He's
put him
getting
on the
old.
docket.
He's already PTI qualified.
Doesn't want PTI?
Well, I think part of the problem is dad
pushing on
is pushing this thing, and then he just listens to dad and doesn't listen to me.
Okay, that's a problem. So why don't we whatever day you want to do next, you want to do something next week?
Maybe next week,
Whatever day.
or in the next week or two, because I don't want to drag it out.
Yeah, so pick a day next week and a day but Friday. Make the
Okay.
appearance required.
Okay.
Hopefully Dad shows up.
I'm gonna tell Dad to show up.
Okay.
Because I think we have a plan on this to just kind of.
It's,
Yes, the state did subpoena his medical records and I provided medical records, but I don't know that that's even gonna make a difference. But just to CYA for me,
that's such a problem.
it's just like,
Bring him in, we'll talk, okay?
thank you.
Hey, don't let them bully you.
Right, no, I don't, Your Honor, but maybe just
I get it.
I'm a people pleaser, so.
You know what? I'm just like you, and can be a real problem when family members just try to take the.
Yes.
Shush, shush.
I like to discipline.
I know, we know. Yes, we know. Ask for a Friday. Hi. Hey, of course.
And it's an off-docket matter.
Sure. What's your cause number?
It's 251-8240.
251.
8240.
8240.
It's Kabir Faizan.
Okay.
And I'm just approaching for Mr. Salinas. He's got a couple motions in the queue. I forgot to ask the clerks to put the motions in the queue. I apologize, you guys. But there's a motion for the list of the state's witnesses.
Okay, so I need them to see it to make sure that they're okay with it. And if they're okay with it, or they have no objections, then I'll sign it for you. Who's next? Vic? I have a problem. Randall. Randall didn't get a PR bond because it looks like he had picked up a burglary of a habitation. That got dismissed 2 days ago. Insufficient evidence to commit the theft. I want to give him a PR bond because that was the only reason and they dismissed it. So it's not fair. He can't make $100 bond. He's stuck. Do you mind bringing Randall out? I need him, or I need to appoint someone immediately because I want to give him a PR bond. Who's your other guy?
Yes, for five. Cruz, Taylor, Stevens. He's right, or he's out there talking. Page 28.
I guess let's just appoint someone else. Cause I don't want to wait. It's already noon. I'm gonna give you a PR bond,
Thank you, Judge.
but I need to give you a lawyer first before we can start talking about your case.
Yes, sir.
But you gotta come back.
I am, Judge. I
Gotta
promise.
come back.
Promise I am. I pull out all my hair and everything on my dreads. Pull out all my dreads.
It'll be fun, man.
Stressing.
All right, so just hang tight. Sorry. Let me just get him another lawyer real quick. I'm gonna bring it back out. We'll talk and then we'll get you out of here.
Thank you, Judge.
Hey, so
Don't send it back yet.
No, he's still got to come back.
he got a Berg hab, but they dismissed it, right? I mean, I'm confirming with you because that's why the magistrate didn't initially give him a PR bond in this case.
What was his name, Your Honor?
Randall, I'm sorry, no, Randall.
Oh, okay. Excuse
Does this have any kind of connection to the theft, Blaze?
No, Your Honor. So the Berghamp was dismissed.
That's the only reason why. I mean, imagine he's unable to, or has no one to post $100 bond to get him out. And the only reason is because of the Berg hab that they didn't give him the PR bond, so.
Berghamp been dismissed, Your Honor, so we defer to court.
Where's the theft from, Alex?
Your Honor, the theft is from a Walmart.
Okay.
Are they sending someone else?
It's right.
Hey, will you do me a favor? Will you stand in the interest of justice for someone, please?
Yes, of course.
Okay. You can bring him out.
Okay.
Miss Al, come on up. We'll give you a cup.
Is this the one, Judge?
No, it's in jail.
Ma'am, 1 second, Abel, we need you, please. Have a seat, he'll be right with you.
This guy did.
So I appointed you a lawyer initially. The lawyer came to reset the case, left. And I don't know if you spoke to him or not. I have Abel here. So you didn't?
No, sir.
Okay.
We didn't talk to him, okay.
So I tried to get you another one. I guess they're giving me a hard time about that, doing that. So I have you now here. I have a great lawyer here standing to help you in the interest of justice because I'm trying to get you out.
Thanks, Judge.
So what happened was you have this theft case from January, okay? You were side on it. You were to come here because they issued you a citation. You were supposed to come here. Apparently, maybe that never happened. I don't know. So that we issued a warrant for your arrest.
Yes, sir.
From what I understand, there was a burglary of a habitation that was charged, that you were ended up charged with, that ended up getting dismissed. And that was the reason why the magistrate did not give him an initial PR bond because of the Berg Hab case. I see now that that case was dismissed 2 days ago because of insufficient evidence. So we're basically holding him on a $100 bond that he's not able to make on a felony that was dismissed for insufficient evidence.
I think he's.
I'm not going to hold you. I'm going to give you a PR bond today. The only thing I am ordering you to do are two things. Don't go to Walmart.
Okay, yes, sir.
Okay? I don't want you going into any Walmart. I'm making that a condition of your bond.
Sir.
I'm giving you a PR bond now, but this is it. If I find that you're a danger to my public, you pick up any new cases, you violate these conditions, I'm going to yank that PR bond in a heartbeat.
Yes, sir.
You understand?
Sir.
I'm not asking much. Keep my streets safe.
Yes, sir.
Don't become a danger. That's when this happens.
That's Judge.
The other thing I'm going to do is I need you to stay in contact with the lawyer. So we're going to give you the contact information for the lawyer that you have now. Please try to get in contact with him. If for some reason you're not able to get in contact with him, come back, let us know, and we can take it further, okay? But you know, technically speaking, you were supposed to get into contact with your lawyer within 24 hours of you being appointed a lawyer. We're going to give you his phone number. Please reach out to him. If you're not able to, just let us know, and we'll take it in a further direction.
That's Judge.
If you have any questions, I have Abel here to help you. You can always ask him and he can answer any questions. He's capable. I trust him with everything that we do.
Sir.
Let's not talk here now because, you know, I don't want you to talk in front of everyone. You guys keep it. So,
Who's the attorney?
well, I don't want to say that.
Okay.
now. So, but do you mind? So regardless, probable cause has been found in your case now, as it is.
Sure.
Okay. So would you mind filing conditions of no going back to Walmart, please?
Sir.
I think probable cause has been found, right? Yes, it has been found. Okay, all right. So any questions you have, I'll direct you to him for now. And then in the reset that we have, I'm going to circle the phone number so that you have the phone number for the lawyer that we have. Just please, when you're released, get in contact with him so you guys can get on the same page. You have to, I'm going to make you, so I want the next appearance required so that we know that they're on the same page. So your next setting, you have to be here, come back so we're all on the same page. After that, I'll waive your appearance.
Yes, sir, Judge.
Okay.
Yes, sir, Judge. Thank you,
Look,
Judge.
Mr. Randall, please be safe, man.
Yes, sir.
Mr. Randall, I'm going to still for the bond process.
Yeah,
One more
yeah.
time, and then, after they put me back down, they'll start process.
Because I think that.
We're keeping the original lawyer on because the MAC didn't let me take him off, right? So I just had this now because I don't want to reset it and keep him in jail because we can't get
No, I understand. So I emailed her and said that, per the defendant, no one has come to talk to him. And I didn't know if that would make a difference to him.
Just don't, let it be. Don't pick a fight.
Oh, man.
All right, are we done? All right, goodbye, guys.